All right, I'm excited because we are doing the hardest part of civil procedure right now, which is the end of the semester when it's spring, summer's coming, we're all going to be happy. So this is exciting for me. So we are doing really well. We know from our last class, Pennoyer. We know the whole point of Pennoyer, my little call list here, is that, remember we talked about, we had all of these changes, right, in terms of, they had the creation of railroads were being laid down, so interstate commerce and corporations, the model of corporations was starting to be adopted by a lot of people. And so it began to cloud judgment in terms of when you have these cases before a judge or people having some type of legal conflict, what power, authority, jurisdiction does the different states, do each individual state have over those people? Like, can I force someone from another state to come and defend themselves against a lawsuit, and if so, under what circumstances? So Pennoyer was just like the first time the court said, you know what, we do need to create some type of rules or parameters. And all Pennoyer said is there are two ways that you can have jurisdiction. A state, or what they call sovereignty, can have jurisdiction over the person, right? One is presence. Are they present in the state? Did you serve them with notice of the lawsuit while they're physically present in the state? And the whole concept behind that was just the notion that if you're in our state boundaries, then we have jurisdiction over your person. If you're in our state, you're going to abide by our rules, and if we think there's been a wrong that's been committed that's related to this state, if we serve you with notice of that lawsuit while you're physically in the state of Kentucky, we can do that. The other one was domicile. Domicile means the same thing as residency. So later on this semester, we'll talk about kind of the formula for determining residency for delinquents like myself. But the point is, if you're domiciled in Kentucky, if I'm considered a Kentucky resident, I don't have to physically be in Kentucky to be served. They can serve me in Texas, Ohio, for a lawsuit against me here in Kentucky, where I'm domiciled, where I live. Is anybody not clear on those two basic things? So are you wondering why I didn't just tell you that instead of having you read Pennoyer? Wouldn't have been a lot easier, right? But I'm telling you, when you interview for jobs, all the attorneys say, oh, what did you think about Pennoyer? It's like the rite of passage. So it's like every law student in the country has to read Pennoyer. It's kind of tradition. And so where we are now with today's case, International Shoe, is finally they're like, okay, we need some more rules. And so what we're going to be doing over the next couple of weeks, is to learn how the court, with each case, they give us another rule. So we know today in International Shoe, now they're going to give us the minimum context rule. So each case is going to give us a rule. And so when we're done with personal jurisdiction, we're going to have this beautiful map that says, to determine whether or not Kentucky has personal jurisdiction over Professor McNeil, these are the things we have to look at. And when you're out in practice, you're going to say, your client's going to say, well, I got this dispute. Sorry about that. I got this dispute. I thought I'd check to make sure my alarms were out, but maybe they're not. I have this dispute that, are there any more alarms? No. I have this dispute against someone who screwed me over on a contract in Indiana. No, that's too close. In New York, and this is what's going on. I'm a single business owner, small business, 10 people. I don't have the funds or the time to fly back and forth to New York to try to hunt this guy down. And they're going to ask you, can you bring the lawsuit here in Kentucky? So as an attorney, you're going to have to decide whether you're doing employment law, patent law, whatever kind of law you're doing, tort law. You're going to have to be able to determine whether or not you can make that person in New York come to Kentucky and defend themselves for your client that's here in Kentucky. So that's why civil procedure is so important. You can't file a lawsuit unless you know what state you can file it in. If you pick the wrong state, the case is going to be dismissed. And that state's not going to have jurisdiction. So that whatever the judgment they made, it won't be binding, it won't be enforceable. So now you've wasted your billable hours, your time, your client's time, and money. And that's very, very bad. So that's why I just want you to know the class is kind of boring in the beginning, but it's very, very important. You can't practice law without civil procedure. Okay? All right. So I'm going to try to keep track of time. I might mess myself up. I have a meeting with the chair of the Department of Medicine, and I didn't know I've never been to the med school. It's downtown.
So I'm trying to figure out how to not be late, because it's a very important meeting. We're trying to do a online collaboration, like a joint degree with the law school. So I decided I'm going to take an Uber, because I figure by the time I walked in my car, get in the car, drive, park in the garage downtown, I'm going to get screwed, right? So I'm going to try to remember to let us out at like 10:05 so I have time to get there. But that's just the plan. So if you see I've forgotten because I'm excited about the class, can you like wave your hand? Okay. All right, let's shoot in. So we've got two attorneys today. We know that you guys did great. Attorney Healy, high five again. And Rangaswamy, there you are. Excellent job. So today, let's get, I like twos because I feel like it's nice to have a partner in crime, especially if you don't know the answer. So let's do Attorney Church. Where are you? All right. You were a target because I like your last name. Attorney Church, and I'm a preacher's kid, and we need some gender diversity. Lineweaver, where are you? Awesome. All right. Got Church and Lineweaver. Okay, so let's go ahead and jump into International Shoe. Do I have a volunteer for either of you just to tell me what the underlying facts dispute is with the case? Thanks.
So, International Shoe is a corporation based in Delaware, but they've got business in other states. This dispute starts with Washington State because they had 11 to 13 salesmen based in Washington, but they didn't want to pay taxes to the unemployment compensation fund. So Washington brings suit against them, and International Shoe is arguing that Washington.
Okay, hold that thought. Okay, so just a fact, and you did a great job. So, very great job. You're prepared. I'm liking you right now. Okay, so we know, very important facts. I just want to say it again that he pointed out because it's important. Where are they incorporated?
Delaware.
Delaware. Principal place of business? St. Louis, Missouri. Or Missouri, depending if you're from there. All right, so that's important. It's kind of like Louisville, Louisville, all that stuff. So, International Shoe, as he did a great job pointing out, and it matters because we're going to talk about this in terms of minimum context. They had 11 to 13 salesmen, right? 11 to 13 employed, 11 to 13 residents in the state of Washington to solicit orders there for their business. They reported directly to the company's main office in St. Louis. That's also important. So, who did they report to? Corporate headquarters in St. Louis. So the state of Washington, as Attorney Church said, they sued International Shoe, basically trying to collect unemployment tax based on the salaries that the defendant paid to their Washington employees. So if you're in the state of Washington, as Mr. Church did a great job stating, you don't want people freeloading in your state. You know, if you're working in my state and enjoying the benefits of my state, you need to pay unemployment tax, the state unemployment tax. So the state of Washington felt like International Shoe was trying to get over and not pay tax that everyone else has to pay, right? So how, Attorney, got your last name that quick, Lineweaver, how did the state of Washington serve notice on the defendant?
They served one of those employees that they had within the state, and they sent notice to the St. Louis office.
Excellent. So there's two ways they did service on the person, right? So one of their salesmen, a solicitor. And then second, they did service, remember it's called constructive service, by mail to International Shoe's corporate office in St. Louis, Missouri. Okay, so those two different ways. So you were jumping into Attorney Church. The defendant, International Shoe's arguments as to why they should not have to pay this tax and why the state of Washington should go jump in a lake. So there are basically three main arguments. What were they?
They're not a corporation in Washington State. They're not doing business there and have no agent within the state.
Excellent. So when you say they had no agent in the state, how does that relate to Penoria? Meaning, what rule in Penoria does that relate to?
The present rule?
Yes, who said that? I'm still learning your names, and I have to turn it backwards. I forgot to tell you all to write it the other way. Is it Jessica?
Yes.
Okay. I'm going to give you another seating chart. All right, so excellent. So I'm going to highlight the three rules that Attorney Church highlighted, and now we have co-counsel Jessica. I can't read your name. It starts with an H, right?
Harper. Sorry,
Harper.
my writing is chicken scratch.
I'll admit it looks like a physician's writing. Just your last name, though. Okay, so we've got three main arguments. So your international shoe, this is what you're telling the judge. Number one, you got the service of process on the sales argument, all right? So you got the service of process on the sales argument. A salesman or sales solicitor is not the appropriate person for service. Why? Because the salesman authority is limited. All they do is show samples, take orders, buyers. They don't have any authority to enter contracts. They don't have any authority to make collections. So essentially what the international shoe is saying, you can't just do service of process on one of our salesmen. And think about how problematic that is. Think about that just for a minute. Imagine you serve process on a Domino's pizza delivery guy. And he hates his job. He's like, I'm just doing this till I find something else. My boss sucks. Domino's sucks. And you think if you serve process on him, what's the likelihood it's going to get to the right people up the chain, right? It's pretty slim. It might. But the point is, that's the argument that International Shoe is making. And so they said the salesmen transmit orders to the defendant's office, again, in St. Louis, Missouri at their headquarters. And so essentially what they're saying is that, if you're going to serve process, it shouldn't be on our salesmen. That's not a legitimate way to provide us with notice. That does not fulfill the 14th and 5th Amendment due process requirements, fairness. Like, that's not fair if we serve it on our solicitor. The second argument they highlight, activities within the state. They say, as Attorney Church said, hey, our activities in the state of Washington are not sufficient enough to confer jurisdiction on us. We're not really in Washington, right? They said, we don't have an office in Washington. We don't have any contacts for sale or purchase. We don't have stock or merchandise in Washington. So essentially what they were saying is, we are not an employer based on the definition of employer in your statute that says we have to pay unemployment taxes. We don't have enough activities there for you to make us pay like the other employers. And then the third argument is no presence in the state, which is what Jessica was highlighting, right? Attorney Harper. Since the International Shoe is essentially saying, since we're not present in the state, it's a denial of due process to subject us to taxation. How are you going to make us pay a tax and we're not even present in the state? You can't do that, right? So that's their argument. So how does the lower court rule Attorney Lineweaver? What do they say?
They found for Washington.
Excellent. So they said that there was personal jurisdiction or not personal jurisdiction over the defendant.
There was.
Excellent. Okay. So we know that Supreme Court in the state of Washington said, we're going to agree with the state of Washington, and yes, we do have personal jurisdiction over you, International Shoe. Pay the tax. All right. What does the Supreme Court say, Attorney Lineweaver?
They also affirmed for the state of Washington.
Excellent. So Supreme Court says, hey, we're not going to overrule that. We agree as well. And so essentially, I think it's important to just take a moment and compare this case to the Penoyer case that we just read, right? We know that International Shoe isn't a resident of Washington. We know that it's incorporated in Delaware and has its principal place of business in Missouri. International Shoe does not have any property in Washington, right? So they don't have any property in Washington. So the court, if they would have had property in Washington, then what could the court do? What could they have done with that property to confer jurisdiction, Attorney Harper?
Could they have done an attachment?
Yeah, and what kind of jurisdiction is that called? Territorial jurisdiction?
In rem? Or quasi in rem?
Quasi in rem, right? But that wasn't an option here. International Shoe didn't have any property in Washington. And thank you. I hate reading upside down. I can't even tell you great job. I think, was it Attorney Lamb? Where's Attorney Lamb? Nope.
Lineweaver, I think.
No, Lineweaver is our attorney for the day, so it's Cole. Thank you for, I'm gonna get you next time, but I did see your hand.
You don't have to get
He's like, don't go. All right, I will not take that personally I'm cool with that. So we know under Panera, the other thing is presence, right? If we were thinking about this case in terms of Penoyer. If you look at the second paragraph on page 83 of your case, second paragraph on page 83. It says, quote, historically, the jurisdiction of courts to render judgment in personam is grounded on their de facto power over the defendant's person. Hence, his presence within the territorial jurisdiction, which just means the state, of a court was a prerequisite to his rendition of a final judgment binding on him. So the Penoyer argument that International Shoe was making is simply that they had no corporate presence, right, in the state. They basically were saying that the solicitation or activities done by their salesmen was not sufficient enough to count, and so no personal jurisdiction, and they shouldn't be subjected to a tax. So this has kind of put the court in a sticky situation because, truth be told, if we strictly apply Penoyer, they don't have jurisdiction, you know? They're not present in the state. They're not their principal place of business is not in the state of Washington. So surprisingly, what does the court do? What do? Attorney Church.
They rule that even if they don't have actual presence in Washington, if they have contacts in the state, Washington is self-jurisdiction.
Excellent. So this is a big deal. They crafted a new rule. They're like, you know what? Yes, if we were to apply Penoyer, there would be no jurisdiction, but this isn't fair. So they said, you know, we're going to create a new rule, and that's essentially what they did. The court stated in the second paragraph, page 83, I think it's paragraph, the sixth sentence, hopefully that's right, but I know it's the second paragraph, page 83. They say, quote, due process requires only that in order to subject a defendant to a judgment in personam, if he be not present within the territory of the forum, we have certain minimum contacts, as Attorney Church said, with it, such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. So in other words, a two-part test you must look at is, one, you look at the quality and nature of the defendant's activities. This is very important. I can absolutely promise and guarantee you every civil procedure professor in the country is going to test you on the International Shoe Rule because you have to use it in practice. So you need to know the two parts to the rule. So again, two-part test called the International Shoe Rule. The first component is you look at the quality and nature of the defendant's activities. Or students will typically put in parentheses minimum contacts, right? You look at the quality and nature of the defendant's activities, simply meaning there must be minimum contacts. How do we feel about that first prong? Does it seem fair? You see any problems with it? Yes.
It could be, I get these mixed up, subjective.
Yeah.
So.
Very. What's minimum? 1, 2, 3 contacts? 4 contacts? How do you determine minimum contacts? That's kind of scary if that's going to determine if I have to come to New York and defend myself, right? Ariana Grande is saying, oh God, I need you to give me a number. Why do you think the court didn't say you have to have 10 contacts or more, 15 contacts or more? Yes.
Maybe it would depend on the size of the corporation.
Size? What other considerations did they think of? Yes, you have had a chance.
Companies would circumvent the rule if there was a
hard line, yes. Companies would circumvent the rule. They figure out a loophole. Oh, we'll do 9 contacts, right? But there's also the flip side of that is now I'm at the mercy of a judge and his opinion on whether or not there's minimum contacts. So the good thing about it is it makes sure that we always have jobs, because it's up to the attorney to make that compelling, moving argument, that LA law argument or whatever they call it. What's it? Law and order argument to convince the judge that there is indeed minimum contacts. Okay, so we know International Shoe, 2-part test. The first one, you look at the quality and nature of the defendant's activities. I'm just stating it again, meaning are there minimum contacts? And then second, whether it's fair. So whether assigning personal jurisdiction would be fair. Whether it would be fair. So what's interesting about this is that what we'll see is as we move on with other cases, they'll say, they'll try to apply this international shoe rule, and they'll realize, fair? That's like, what's justice versus fair? Remember we did that at the beginning? That's very, you want to talk subjective. And so there is another case we'll cover where the court says, okay, we recognize this is too ambiguous, so these are the factors you look at to determine fairness. So, you know, it'll just keep, that's why I'm saying it's a puzzle, personal jurisdiction. They'll keep adding pieces and helping us see the overall framework. Okay, so we know they crafted this two-part rule. The emphasis on fairness is a really big shift from Pennoyer, which turned on issues of state sovereignty, state control over people within their presence, not whether or not it would be fair to the individual defendant. Pennoyer could care less about fairness, right? So the court actually didn't examine fairness at all in Pennoyer. So this is a paradigm shift we see occurring with the court system. So what does it mean for a corporation then to be present, right, to permit the exercise of personal jurisdiction under this new international shoe test? In other words, how do you evaluate minimum contacts? If you look at the last two paragraphs on page 83, the court suggests two principal things. Again, in terms of how do you actually evaluate minimum contacts, the court suggests two principal things in the last two paragraphs on page 83. One, they tell you to look at the extent of the activities, meaning are they continuous and systematic as opposed to casual or isolated. So again, the court says, you know, here are two principal things you can look at to determine whether there are minimum contacts. First, the extent of the activities. Are they continuous and systematic as opposed to casual or isolated? Are they continuous and systematic? Sorry. Everyone looked up. Sorry about that. I burned my mouth. I didn't know it was that hot. 911. Okay. I mean that sincerely. And then second, they said you look at the relatedness of the activities to the cause of action. Relatedness, and I'll explain what that means, of the activities to the cause of action. The relatedness of the activities to the cause of action. You know, this is more law statement. So you look at the relatedness of activities to the cause of action. So basically you look at whether or not there's a causal connection between the lawsuit or the legal dispute and the defendant's activities within that state. So are international shoes activities in that state selling stuff related to the lawsuit? They're saying your activities in the state require you to pay an unemployment tax that you're not paying. So you look at the relatedness of the activities, right? The relatedness of the activities to the cause of action. So the point I just made helps you distinguish between specific jurisdiction and general jurisdiction. So here's what we know so far, brilliant scholars, right? We know that to file a case in civil court, you need what? You need jurisdiction. And how do you determine if there's jurisdiction? You need, what type of jurisdiction do you need? Maybe that's the better way of asking.
Personal and then
It's not a joke, personal jurisdiction, right? I mean, it's not a trick. So to file a case in civil court, we know you need personal jurisdiction, which is what we're discussing now. We know you need subject matter jurisdiction, which I said on the first day of class. We know that you need venue. We know you need proper service of process. So, you know, we need all these things, not one. So right now we're just discussing this one requirement. Right? And so we know there's different types of jurisdictions. Someone said quasi-in rem, right? A personal jurisdiction. In rem we've learned about. And now we've just learned about specific jurisdiction. So there's specific jurisdiction and general jurisdiction. So what's going to happen at the end of the semester, you're going to have several different types of personal jurisdiction, pathways to achieving personal jurisdiction, to establishing personal jurisdiction. So in your text, today's readings, they distinguish between specific and general jurisdiction, which again are types of personal jurisdiction. I want to make sure I'm clear about that. It's actually described on page 88, just making sure I wrote the page down of your text. And I encourage you to put a little star about that and look at it later. So, general jurisdiction is where the cause of action arises from dealings entirely distinct from the corporation or the defendant's activities within the state. So again, general jurisdiction, which is described on page 88 in your text, occurs where the cause of action arises from dealings. The cause of action arises from dealings entirely distinct from the corporation, or the defendant's activities within the state. One more time. General jurisdiction is where the cause of action arises from dealings entirely distinct from the corporation's or the defendant's activities within the state. We will spend an entire week looking at cases where there is general jurisdiction, so you know what that looks like, okay? An entire week on that. The test to determine whether there is general jurisdiction is whether the defendant's contacts are substantial enough. So you see the difference. Specific jurisdiction requires minimum contacts, which is a lower bar. General jurisdiction is a higher bar. You gotta have substantial contacts. So again, the way to determine if there's general jurisdiction is if the defendant's contacts within the state are substantial enough, right, such that the case can be brought against the defendant even if the case is unrelated to the defendant's activities within that state. So essentially what they're saying is we don't care if the case is a breach of contract and it has nothing to do with your activities within the state. If your contacts within the state of Kentucky are substantial enough, basically we can sue you for anything, okay? So again, the way to determine general jurisdiction is if the defendant's contacts with the state are substantial enough such that the case can be brought against the defendant even if the case is unrelated to the defendant's activities within the state. They use an example on that page, that 88 page reference I made. They use basically the Microsoft Corporation has its chief place of business in Washington State. And Microsoft can be sued in Washington even over contracts or torts committed in Idaho or Texas because they have substantial contacts in that state. So if I have an issue with Microsoft or Amazon and I want to go, I can go to their headquarters. If I can't figure out how to have jurisdiction here in Kentucky, I can always sue them where their principal place of business is. And that's fair. We don't want corporations, as you said, to try to evade process or try to, game the system. So I think that's fair. We agree, hopefully, right? All right. Specific jurisdiction. So specific jurisdiction, then, is when the activities of the corporation are the basis of the lawsuit. So again, the activities of the corporation are the basis of the lawsuit. So you see the distinction. Doesn't matter with general jurisdiction if the activities don't have to be related to the lawsuit. But specific jurisdiction requires that the defendant's activities in that state are related to the lawsuit. Okay? So again, specific jurisdiction is when activities of the corporation are the basis of the lawsuit. And when I repeat it a million times, it's for people that are handwriting, because they can't type as fast as you can. So it's not that I think you're slow. You wouldn't be here if you were very bright students. All right. 932, have a question. Side note. Have you all seen the support animals that people are allowed to have?
Yes.
Right? So it's a true story. So I was on a plane last week, and somebody had a squirrel. And at first I'm like, oh, how cute, right? And it's one of the things where there's just two, an A and a B row. I was like, oh, he's so cute. And I was like, hi, squirrel. You know what he did? Right? And I was like, oh. And so like the whole plane ride, my heart was like this. I'm like, he's gonna like, if I take, because I was tired too, I'm like, if I take a nap, he's gonna, he's gonna like scar me for life. This little guy's out of control. But yeah, he was like really, he wasn't a cute cuddly squirrel that you would let your kid touch. He was like a little squirrel with like a Chihuahua spirit in him, like just a little spicer. And so I was thinking like, Should they have limits? When Laura Rothstein would kill me for saying this, should they have limits on what types of support animals you can bring on planes?
I thought they do. We did a whole class
talked
on
about
it.
this.
Why, was the squirrel allowed? Was that
I
allowed to
thought,
bring a
I
squirrel?
thought you could only have a miniature horse and a dog.
You can bring a miniature horse
Maybe
on
not
the
on a
plane.
plane, but.
Are you
Is it-
serious? Behind me, they're saying a miniature horse? That's not true.
I wonder if
I'm
it
not
has to be
sure.
like
Yeah,
certified.
they said that was one of the two
For religions
official
that
ones.
think dogs are dirty.
I'm not sure that.
For
I
the
know-
people that were allergic to dogs.
Yeah,
or
no
something.
way. I haven't seen the miniature horse, but this was a squirrel. This was last week, and I'm still like, I'm still traumatized because I was like, I felt like, you know, this is me being dramatic, but I feel like I was being exposed to trauma. Just like I couldn't enjoy the plane ride because I felt like it needed more. And part of what I think influenced me is there's a guy, if you Google it, it was American Airlines, but this guy was mauled by a dog. It was a support dog, and he was in the window seat, and the dog actually mauled him. Like he had to, like half of his face, like he ripped his face. Like he has, like his face is permanently deformed. And I was upset about that, and I think that story's always stuck with me. So when the squirrel, then I was like, he's gonna totally take my face out. But I think that's what happened.
So
All
was
right.
it out of a cage?
I don't
It
believe
was.
she
Yeah,
was
he had him in the cage, but he was sitting in his lap, and I was like, no, like not good.
That's nasty.
Yeah, squirrel. So sometimes this material can get really dense, so I will share my crazy life stories just because I don't want you to be bored, because I hate being bored. And that's a real story, and I just thought I'd share. All right. Yeah. So who can tell me, before I move on to see how quickly you retain information, difference between specific and general jurisdiction? Besides, yes, Jessica.
Specific has to deal with the defendant's activities in the state, and general does not.
Excellent. All right. Moving on. And for general, you need what level of context?
Substantial.
Excellent. You know, of course, as anything with law, that's going to change later too, just like Penoyer changed on you. So we'll see. That's why with this class, like if you don't read and get behind, you won't understand like how everything fits together, and you'll be like, oh, Penoyer's still no, it's not. Penoyer's not good law anymore. But it's everything. They're building blocks, and that's why I have to be kind of anal about you being prepared because it's really hard to catch up. It's not like court. All right. So when the defendant's activities fall short of general jurisdiction, what you would do as an attorney is say, okay, well, they don't have substantial contacts in the state. Let me see if they have minimum contacts. Maybe I can get the case filed there through specific jurisdiction. So if we apply this two-part test, minimum contacts test, Attorney Lineweaver, to the facts in International Shoe, are there sufficient minimum contacts? And if so, how do we determine that?
Yes, because they have the employees within the state working and selling shoes to their residents of the state.
What else?
They were being paid salaries.
Yep, being paid salaries. Anything else you see in the facts?
Well, they were enjoying the rights of the state, so they have the right to bring suit within the state against somebody that maybe would do it wrong to them. So at least that's what the court said. So we felt that they should, within that qualified for having minimum contracts, they're afforded the rights of that state.
Excellent. When you say they were enjoying the rights of the state, do you know what the court was referencing? They don't really specifically spell it out. What do you think they meant by it?
Well, that they could bring their suit if they wanted to against someone in that state.
Yeah, and another thing we'll see when we read some more cases when they say they're enjoying the rights of the state, they're saying, look, when you're in the state of Kentucky, you can at any point in time dial 911. You have the protection of our policing service, our medical service, hospitals. You're driving on our roads. Like you're enjoying the benefits of being in the state of Kentucky. And sometimes there are some responsibilities or what's a better word?
Privileges?
Privileges, thank you, that are attached. Thank you very much. Are attached to being present in that particular state. Okay, so we know that in determining whether or not there's sufficient contacts, I'm just going to repeat what Attorney Lineweaver said. Everything she said was correct. She's just way in the back so that the people on the side can hear. So yes, there are lots of activities. If you look at the facts, which is what you would do out in the real world, 11 to 13, as Attorney Church said earlier, in-state salesmen are residing in Washington, regularly selling shoes in Washington. Even if they're supervised from Missouri, the salesman generated $31,000. That's pretty significant back then, if you look at the case being dated. In commissions from shoe sales, Plus, the defendant gives salespeople samples and pays for rental space in the state of Washington. So the court basically says that these activities count as systematic and continuous. Plus, there's a large volume, the court said, of interstate business. The defendant received, again, the benefits and protections of the state, as I was just discussing with Attorney Lineweaver. And more important, for a specific jurisdiction, this lawsuit arose out of that defendant's activities within the state. But what about the second prong? Because remember, there's two, fairness, right? It has to be fair to force this non-resident defendant to come and defend themselves in the state of Washington. The court says, what about that, Attorney Church? Do they say that personal jurisdiction would be fair? Why or why not?
They say it would be fair. Is it because the suit came out of the activities that were going on in the state?
Somewhat, yes. Can you tell me where on the page 84, second last paragraph, is there anything there that would support what you're saying?
They were neither regular nor casual.
It is evident.
It is evident that these operations establish sufficient contact or ties with the state or performed to make it reasonable and just according to our traditional conception of fair play and substantial justice to permit the state to enforce the obligations which appellant has incurred there.
Excellent. All right. So is there personal jurisdiction in this case? Obviously, the answer is yes. Is there a specific jurisdiction or general jurisdiction? I've said the answer already, but what is that, Attorney Lineweaver?
Sorry, can you repeat the question?
Whether there's specific or general jurisdiction.
Specific.
Yeah, excellent. All right. Because
They did the minimum contacts test.
yes, but why is there a specific versus general jurisdiction? I want you to say it so that you know it for the exam.
Well, the general, they only you have to have substantial contact within general.
Okay, yeah, so we know there's no substantial contacts, and what is unique about the type of lawsuit that is qualified for a specific jurisdiction?
What was the first?
What is unique about the type of lawsuit that qualifies for a specific jurisdiction? What type of lawsuit? What has to be, what connection do you need? You know this. I'm trying to figure out how to ask without telling you the answer, but I know you know the answer. You do. So tell me what type of lawsuit, if you don't talk about contacts, general jurisdiction, I can bring any type of lawsuit, right? Against. Yeah, because they have substantial contacts in the state. So for specific jurisdiction, in addition to having minimum contacts, what's the other requirement?
It has to be fair. When the activities of the corporation are the basis of lawsuit.
Perfect. Told you knew it. All right. So the case has to arise out of the defendant's activities within the state. So, all right. Any questions about? The only time I say no questions is Penoria because it freaks everybody out. But we're back in regular class mode. Any questions about international shoe? Do you understand international shoe?
Yeah, I think I get it, or I do get it, but,
Okay.
so now like Amazon or something, they wouldn't send a salesman, they'd just have the website, right? So they could do business in Washington.
Yeah, so we'll have a whole case on how do you determine jurisdiction for online entities. There's a sliding test that you use, a sliding scale. So in a future class, but for now, based on Amazon, this is too premature to address that, which is why they had to create another rule. This is before the internet was here. All right, let's go ahead.